All right, well, good evening, everyone, and welcome to Estate Administration Week. My name is Noel Xavier, and I am the Director of Donor Services with Edmonton Community Foundation. It's my pleasure to be your host for this session, and we are so happy that you could join us tonight. Many of you are already familiar with our annual Wills Week, which is held every October. This week, we're launching a new series of presentations that are similar to those you've attended for Wills Week, but with a specific focus on the ins and outs of effectively administering an estate. At the Edmonton Community Foundation, our role is to help people create their legacy for our community. We are a trusted resource for Edmontonians to provide ongoing endowment support for the charitable organizations and issues that they care about. As a result, we have many conversations with people in our community about their wills and estate plans. And we know how important it is for people to learn valuable information from wills and estate professionals. Just before I introduce our presenter for today's session, I would like to let you know that at the end of the session, you'll be given the opportunity to fill out a survey. As this is the first time we're hosting Estate Administration Week, your feedback is valuable to us, and it will help us to plan for next year. So please be sure to fill it out. Today's session is being recorded, and it will be available by the end of the month on our website at www.ecfoundation.org. And so you will be able to look at this presentation again, and we hope that you will encourage your family and friends to watch it as well. Now, we will have some time at the end for questions. This is how I will ask all of you to participate in the questions. If you've got a question for our presenter, please put it into the Q&A function of your Zoom. Now, for most of you, that should be at the bottom of the screen, depending on the Zoom version that you have. So please put your questions in the Q&A, as I will not be able to monitor chat as I'll be doing the slides as well. So questions in the Q&A, and then we'll go through them at the end for our presenter. So thank you for your cooperation on that in advance. So now I would like to introduce our presenter. And she's no stranger to the Edmonton Community Foundation, and certainly no stranger to Wills Week. I'm sure many of you have heard her before. So I'd like to welcome Shelly Chamaschuk. Shelly's practice focuses on corporate and commercial matters, business and succession planning, estate planning, including wills, enduring powers of attorney, personal directives, family trusts, and estate administration. She is the firm's wills, estates, and trust team lead. Prior to entering law, Shelly worked for the Capital Health Authority and was the regional coordinator for the Department of Laboratory Medicine. She also worked overseas as a medical laboratory technologist in Saudi Arabia and with a humanitarian aid project in Kiev, Ukraine. Shelly is a member of the Edmonton Bar Association, the Law Society of Alberta, a committee member for the Advanced Care Planning CREO program, a member of the Society of Trust and Estate Practitioners Canada, the Canadian Bar Association, and she's on the executive committee of the Canadian Bar Association Wills, Estates, and Trust section. Shelly serves on the Surrogate Rule Advisory Subcommittee as the Law Society of Alberta appointee and is a member of the Advanced Care Planning Advisory Committee in Alberta. She was also named one of the 2021 best lawyers in the area of trusts and estates. She also provides her expertise as a presenter, as I've said, for the Edmonton Community Foundation, and we're very thrilled for that, Shelly, thank you. A lecturer for the Legal Education Society of Alberta. She's a past presenter for Metro Continuing Education at Edmonton Public Schools, and is a past president for Youth Empowerment and Support Services. We know them as YES in our community, and she's been on their board from 2003 to 2012. So everyone, please help me welcome Shelly Chamaschuk. I'll turn it over to you now, Shelly.
Thank you very much, Noel, and thank you everybody for joining us tonight. So we're going to spend the next hour talking about estate administration, and we've entitled this presentation Executor Duties 101. So it's the basics in what to expect if you are an executor. So my next slide is just an outline of what we're going to talk about. So we're going to talk generally about wills, where to find them when somebody has passed away, funeral arrangements, what is a grant of probate and a grant of administration, what the general duties and authority of executors are, the core tasks that executors are expected to fulfill, and that includes managing the estate and finally distribution to beneficiaries. So our first topic is wills and funeral arrangements. So when somebody's passed away, the first step is to find the will. And this is important because the executor of the estate is the person who has the authority to make funeral arrangements for the deceased person. So we always want to figure out who that person is who has that authority. So we need to find the will. So places to look for the will, if you don't, if you're the executor or you think that you've been appointed as the executor and you're not sure where that will might be, you're going to look into a safety deposit box. If the deceased had a safety deposit box, they might have. It's more common to have a home safe now. It might be there. Might be with other personal documents or important papers of the deceased, or it might be at the lawyer's office where the deceased made a will. So you want to look through all of those places thoroughly to find a will, or even just to rule out whether or not the person who's passed away has a will. And so, as I had said, it is the executor of the will that has the first authority to plan the funeral. Now, if there is no will, then in the Funeral Services Act regulations, there is a list of people who have the next authority to plan the funeral, and so that would be the who you would probably expect. So a spouse or a partner of the deceased person, if there is no will, and if there is no living spouse or partner, then it would be adult children. If there's no adult children, then it would be a parent. That's that sort of thing. So there's a list of people with priorities to make funeral arrangements, and that's who the funeral homes will be looking to attend at their funeral home to make those arrangements. It's also important to determine whether or not there is a pre-planned funeral arrangement. And so you want to really make sure that if there have been some arrangements that have been made for the funeral, that you honor those arrangements and you use that pre-planned funeral home to carry out the funeral. So because there have been payments that have been made for that funeral. I have had circumstances where it it didn't become evident to the executor that there was a pre-planned funeral arrangements that had been made until after the funeral was over. So that was really unfortunate and costly to the estate. So you want to make sure that you are aware of that, and you've searched all the important papers to figure out whether or not that has happened. And hopefully the deceased person would have put that in their will, or have told you or family members that they have made some funeral arrangements prior to their death. If there is a list of wishes that have been left by the deceased, then the executor should do their best to fulfill those wishes if they're legal and reasonable and it's possible to fulfill those wishes. Um, and I just wanted to mention the payment of funeral expenses because um, funerals can be very costly. And what you want to do is to make funeral arrangements and then take the invoice from the funeral home to the deceased bank. And most financial institutions will pay that invoice for the funeral from the deceased bank account so that you don't have to incur out of pocket expenses in paying for that funeral and then getting reimbursed later because it might take some time for you to have access to the deceased bank account and funds, depending where they're held and what needs to happen in terms of the estate administration. So the key there is that a financial institution will pay the invoice of a funeral home directly to that funeral home, but they're much less likely to reimburse somebody, whether it's an executor or another family member who's paid the funeral home for those funeral arrangements. So that's my tip there. So next we're going to talk about a grant of probate and a grant of administration. So people are often confused by these terms, and so I thought I'd take a minute to just explain them. So a grant of probate is something that is obtained when the deceased has died with a will. So when a person has died with a will, we say that person has died testate, and then you're going to seek a grant of probate of the will. When a person dies without a will, we say that that person died intestate, and in that case, there is no will to probate, so we have to get a grant of administration to give somebody the authority to, in essence, be the executor or the administrator of that estate. So we have two different things going on: grant of probate if there is a will, grant of administration if there is no will. And I'll people often ask me, what does it mean to get a grant of probate? What's that process? What's actually going on there? And so a grant of probate is a process with the court where um, you are confirming the validity of the will, and it is a process that protects the instructions of the deceased person as they're set out in that person's will. The process of obtaining a grant of probate confirms the person that's appointed in the will to be the executor of the estate. Often executors are called personal representatives, so those terms can be used interchangeably. But it's confirming the authority of the executor, and oftentimes people want to avoid probate because they feel like it's costly, or they've read information online or through other sources that talk about estate taxes and applying for probate. But in Alberta, we don't have estate taxes, and so wanting to avoid probate is not a major concern as it is in other jurisdictions. So if you are reading information and they're talking about avoiding probate in order to avoid estate taxes, please remember that that information may be pertaining to a different jurisdiction outside of Alberta where there are estate taxes. So trying to avoid probate in Alberta is not something that we encourage, or that I think is important, because there are no probate fees or probate taxes that come along with that in Alberta. And what's important about getting a grant of probate is that there are some timelines in our legislation that don't start until the grant of probate is issued. So in terms of people being able to make claims on the estate, that doesn't start until the grant of probate is issued. And so you need to start that clock so that that time frame will expire. And you do that by getting a grant of probate. So in that way, it protects family members who may have a claim on the estate, and their claim may only be able to be brought forward by them for a number of months. Often it's 6 months or 12 months. And so you need to start that clock, and everybody needs to know when that clock starts and when that time frame expires. And you do that by obtaining a grant of probate. The grant of probate protects an executor against claims and lawsuits about about the executor distributing an estate when there was still a time frame running for somebody to come forward to make a claim. So it's from an executor's perspective, obtaining a grant of probate is a prudent and wise step. And once a will has been probated, everyone can rely on the authenticity of the will and the authority of that executor. So, in institutions, banks, and other institutions, they don't have to be concerned about somebody else coming forward and saying, no, that's not the last will. of the deceased person. I have the last will here, and I am the rightful executor of the estate. So it helps everybody know who has authority over this estate. So I'm of the view that it is the prudent thing to do to apply for a grant of probate when that is necessary. So when do you need to apply for a grant of probate? In Alberta, there's really two circumstances where you need to apply for a grant. The first one is where the deceased owned land or mines and minerals that were registered in just the deceased name alone. And this is because our land titles office here in Alberta will not register a transfer of land without a grant being submitted along with the land transfer documents. So if the deceased who passed away has a home or land just in their own name, you're going to have to apply for a grant of probate in order to transfer that land either to a third party if you're selling that land, or to a beneficiary named in the will. The other circumstance where you need to apply for a grant is where the deceased had bank accounts or investment accounts that were just in their own names. Um, in that situation, we have financial institutions that will have their own rules, policies, and procedures about when they will distribute or release funds that are in an account without a grant, and when they require a grant. And so this is really a risk management task on the part of financial institutions. So financial institutions will have a threshold of a dollar amount over which they say, we're no longer willing to take the risk that we're dealing with the last will of the deceased person and that we're dealing with the right executor. And so we need the executor to go and get a grant that tells us that they are the person that has authority to deal with this estate, to deal with this bank account or investment account, and we can release funds to them, knowing that that there isn't going to be somebody who's going to come after them and produce a more current will and be the person who actually has the better authority to be the executor. So those are typically the two reasons why people need to apply for either a grant of probate if there is a will, or a grant of administration if there is no will. And unfortunately, there's just no way of getting around those two circumstances. Um, Oftentimes when you have spouses or partners who have held all of their property, whether it's land or bank accounts and investment accounts, those types of things, they've held them all of their property jointly, then there is no need to apply for a grant because those assets will pass to the surviving spouse or partner without the need to apply for a grant of probate or a grant of administration. So when you have spouses or partners and the first of that couple passes away, often if they've held everything jointly, everything just rolls over to that surviving spouse or partner. And it's when the second of them passes away that we no longer have a surviving joint partner, and then there's the requirement to apply for a grant. Next slide, please. Uh, so when you are applying for a grant of probate or administration, you are going, I refer to that as a formal executor. Informal executors are where there's no requirement to apply for a grant, but somebody is going to act and administer the estate. And so it was the case in the past where we would often have beneficiaries who would call and they would be concerned because they knew that they were likely the beneficiary of a parent's estate or a grandparent's estate, but they didn't know who was administering the estate, whether there was a will, whether they were a beneficiary, what was happening, or they knew that somebody was, starting to administer the estate, but they didn't need to apply for a grant, so the beneficiary didn't get notice, and they didn't know what was happening, or there was a will, and the person who was appointed as the executor in the estate wasn't taking any steps or keeping them informed of what was going on. And there were a lot of court applications that were necessary in order to push that person to either step into the shoes of the executor and to perform those tasks, or to step aside and allow somebody else to apply to be the executor and to administer the estate. So the government tried to rectify that in the Administration Estates Act that was reformed in 2015, where there is now a notice requirement. So even if you're not having to apply for a grant, but you are going to administer somebody's estate, you must give notice to certain individuals. So if there is a will, you have to give notice to all of the beneficiaries that you are going to administer the estate, even though you don't have to apply for a grant of probate, because through that grant process, there is a requirement to give notices. And so if there's a will, you give notice to all the beneficiaries that you are going to fulfill the job of being the executor. If there is no will, then there's a list of people who are entitled to get notice from you. And those would be the people that you would typically expect. So a spouse, a partner, adult interdependent partner, or which is our legal term for a common law spouse in Alberta. You have to give notice to adult children if they're unable to earn a livelihood due to a mental or physical disability, because they may be entitled to some support from the estate. Um, a child who is 18, between 18 and 22 years old, and a full-time student who is supported by the deceased person is entitled to notice. And you have to give notice to the public trustee if the deceased had a child that was under the age of 18, or a grandchild or great-grandchild under the age of 18, to whom the deceased person stood in the place of parent. So these are all individuals who may have a claim on that deceased estate, and they are entitled to receive notice from this informal executor that they are going to proceed with administering the estate. And then there are some rules about what that notice must contain, the type of information that must be in that notice. So um, you have to indicate who has passed away and provide the name and contact information of the executor who is going to administer the estate, describe the gift that the beneficiary in the will would be entitled to, or the gift that the beneficiary would receive under our legislation, because there is no will, and we call that is intestate succession legislation in our Wills and Succession Act. And the notice also has to state that all the gifts are subject to the prior payment of debts and claims against the estate. So it's a very bare bones notice, but at least it's a start in advising people that they are a beneficiary of the estate, who the executor is, and that that executor is going to take steps to administer the estate. So now I'm going to just spend a few minutes talking about the general duties of an executor. And these duties are set out in our legislation. And our legislation says that an executor must perform the role of executor honestly and in good faith, according to the deceased's intentions in the will, um, and with care, diligence, and skill that a person of ordinary prudence would exercise in comparable circumstances where a fiduciary relationship exists. So fiduciary means that there is a trust relationship. You're holding assets in trust for the beneficiary. And it's a very important relationship that comes with a lot of responsibilities, and the executor must distribute the estate as soon as practicable. So that was added to our legislation in the last round of revisions to try and avoid circumstances where estates would go on and on and on, and it would take, sometimes years for an estate to be administered. So the legislation is trying to deal with some of the problems that would commonly come up in estates when we had an executor who wasn't moving forward with their duties. It's important to know that an executor is a trustee, and that means that their actions are governed by the Trustee Act. So that imposes, some serious obligations on the trustee to act fairly and responsibly, because you're looking after assets that will eventually be distributed to others, to the beneficiaries. And where you have an executor who is a professional, they are held to a higher standard of skill when they're acting as a professional in administering an estate and acting as an executor. So the executor's authority comes from the will and comes from the legislation. And our legislation specifically says that the executor has the following authority in regard to estate property. They have the authority to take possession and control of the estate property, to do anything in relation to that property that the deceased could do. So they're stepping into the shoes of the deceased, and to do all things concerning the property of the deceased necessary to give effect to any authority or powers vested in the executor, which really just means that they have the authority to deal with all of the assets and debts of the deceased person in order to administer the estate and to transfer those assets to the beneficiaries, either under the will or the beneficiaries under our intestate succession legislation, if there is no will. So our legislation also sets out the core tasks that must be carried out by an executor, and it lists these as the core tasks. The executor must identify the estate assets and the estate liabilities. They must administer and manage the estate. They have to pay the debts and obligations of the deceased person from the deceased funds, and distribute and account for the administration of the estate. So distribute the estate to the beneficiaries and account to the beneficiaries for the work that they have done in administering the estate of the deceased. And where the executor fails to provide notice or to perform these core tasks, the court has a few options available to them. The court can order the executor to perform the tasks that they are not performing for whatever reason. They can impose conditions on the executor. So, for example, they can impose a time frame where an executor must get certain tasks performed, finished, and completed. If we have an executor who's kind of malingering and not moving forward with the administration of the estate, that's the most common circumstances we find. The court in very extreme circumstances can remove the executor from their position and appoint somebody else to take over as the executor of the estate if an executor is doing a poor job, a very, very poor job, or not taking any steps at all. The court can revoke a grant. So if the court has issued a grant of probate or a grant of administration to an executor, and that executor is not properly fulfilling their duties, then that grant can be revoked. And the court can make any other order that it considers appropriate in the circumstances. So a lot of leeway for the court to try and correct a situation where an executor is not performing their duties appropriately. And so this would come about. The process for bringing this about is typically the beneficiaries would bring a court application, or somebody who is interested in the estate, maybe a creditor, would bring a court application to try and force the executor to move forward with administration of the estate and fulfill their duties appropriately and correctly, or bring an application to have that executor removed because either the executor is not taking any steps or not taking reasonable steps to administer the estate. Our legislation also says that there are additional duties in addition to those core tasks that an executor must fulfill. So they must, in addition to dealing with beneficiaries, they must also give notice to claimants, creditors and claimants of an estate. So if they know that somebody potentially has a claim against the estate, they need to give notice to that person or entity. The executor is also required where somebody comes forward and says that they have a claim against the state. It's up to the executor to verify that claim and make sure that that is a justifiable claim against the estate. Where there is a dispute about whether a claim is legitimate or not, it's up to the executor to decide whether a claim is legitimate and what the quantum of that claim is. And if they aren't able to do that, oftentimes they would go to the court and ask the court for some assistance through a court application to help them decide a contested claim, and to decide whether a claim is valid and what the amount of that claim might be. And the executors also are required to rank debts. This would be in the case of an estate where there are not enough funds in the estate to pay all of the debts. The executor is required to decide which debts will be paid, and there's some case law and some legislation about which debts have the first priorities to be paid over other debts. But again, that is a responsibility of the executors to fulfill. Those are very difficult estates to administer, and those are estates where an executor might want to take a step back and decide whether or not they actually want to get involved with being an executor of an insolvent estate or a bankrupt estate, because it can be very, very difficult when of course you have more claims than you have funds to fulfill those claims. So just to get into a little bit more detail on those core tasks and some of the first things that you would want to do as an executor. So an executor wants to, first of all, identify the assets and the liabilities of the estate. And so that means going out and identifying and locating all of the assets of the deceased. So you want to, once you identify assets, you want to keep those assets safe and secure. That means that you want to maintain insurance on assets where that's appropriate. So if there is a house or land that forms part of the estate, you want to make sure that property continues to be insured, the insurance is valid. You want to give notice to the insurance company that the deceased has passed away. Some people are reluctant, some executors are reluctant to do that because they think the insurance company might cancel the insurance, or their premiums might go up. But most policies have a clause in them that say that if somebody has passed away, the insured person, the person who owns the property has passed away and they're not notified, that within a reasonable period of time that insurance becomes invalid. So you want to make sure that you're notifying insurance companies when there's houses or vehicles or other assets that are insured of the death of the owner of that property. If there's a safety deposit box, you want to take inventory of the safety deposit box contents. Often a bank will be reluctant to turn over the contents of that safety deposit box to you, but they will often agree to allow the executor to go into a safety deposit box while there is an attendant from the bank with that person to look through the safety deposit box to see if there is a will, and then to make an inventory of the safety deposit box for the purposes of estate administration. Then everything that's in that safety deposit box goes back into that box, and that box remains at the bank, and the contents remain in that box until a grant of either probate or administration is obtained. And then after the bank knows that they're dealing with the person who has the proper authority to be the executor, then they would release the contents of the safety deposit box to the executor. So it's a little bit tricky when the will is in the safety deposit box and the bank is refusing to let somebody in to a safety deposit box to look for a will. But typically you can negotiate your way through that and at least get into the safety deposit box to search for a will or other important papers of the deceased. So the other thing that the executor needs to do is to value all of the assets in a reasonable way. And they need to locate all the bank accounts and investment accounts of the deceased person. So all registered accounts like RRSPs and RIFs and TFSAs and any other investment accounts that the deceased may have. They also want to locate any life insurance policies that the deceased had and identify the beneficiaries of those policies. Does that insurance policy not have a beneficiary named on it, or has named the estate as the beneficiary? In that case, the funds from the proceeds of that insurance policy would come into the estate, or the deceased named a beneficiary on their insurance policy. And so it would be up to the insurance company then to notify the beneficiary of their entitlement to the proceeds of that life insurance. So when you're performing these core tasks, there are many parties that you have to notify as the executor of the estate. So you want to notify the banks where the deceased held accounts. You want to notify credit card companies, ask for a final credit card statement, and then get that card canceled. Advise them that the deceased has passed away, so they'll put a stop on the use of that credit card. You want to cancel other cards like healthcare cards, driver's license, passports, social insurance numbers. That's all really for identity theft purposes to make sure that nobody has those numbers and would be using any of that photo identification for nefarious purposes. You would want to notify any subscription providers. If the deceased has subscriptions, you want to let them know that the deceased has passed away to stop those subscriptions from continuing. Perhaps there is a refund that the estate might be entitled to if they've prepaid for a year's subscription for a magazine or something like that. Or something like an AMA membership, that type of thing. You also want to notify CRA that the deceased has passed away, as well as the Canadian Pension Plan and Old Age Security, other pension plans where the deceased might be receiving monthly pensions or payments from any organization. And you might think that if you notify one federal government agency, then they would they have a system where they would be able to there would be an internal system to notify all of the other organizations within the federal government, and that seems not to be the case. So sometimes you have to notify each one of those different departments in order to cover all the bases there. And if the deceased had memberships, you want to cancel those memberships. And one of the things that can be tricky is just dealing with social media accounts and taking control of those and getting those canceled, or at least having control over the use of those social media accounts that the deceased had. So lots of notifications that need to happen when somebody has passed away. So then the next steps are that are to apply for a grant of probate or administration if you have um, determined that a grant is required. And then once you have that grant, then you're able to more easily manage the estate and then gather all the funds into one account, into one estate account so that they can be distributed to the beneficiaries. The executor is also responsible for filing the tax returns of the deceased person. So typically that there are at least two tax returns that need to be filed. One is the personal tax return for the year of death of that person. So that's sometimes called the terminal return. And there's often then a second tax return that needs to be filed, which is called the estate tax return. So the first tax return is the year of death up to the date that the person passed away. And then from that date forward until all the funds are distributed out of the estate, there could be interest or income that's earned in the accounts of the deceased person. And so that income and needs to be reported in an estate trust return. And so if you're able to distribute the estate within a year of death, then there may be only one estate trust return that's required. But if not, then every year that the estate continues, there has to be a trust return that is filed if there was income earned by the estate in that year. So filing tax returns is a very important responsibility of the executor because it's one of um, the areas where the executor does have personal liability. So if an executor distributes estate assets without paying the taxes first, they can be found personally liable for the taxes that are owing to CRA. So that's why it's very important to apply for a clearance certificate from CRA if you're concerned about whether the deceased person was up to date with their tax filings and whether or not the tax filings have been completed and filed appropriately and all of the taxes have been paid. You apply for a clearance certificate from CRA, and once you have that clearance certificate, then CRA is no longer able to come back to the estate for taxes. So they have reviewed the file of the deceased person and determined that the deceased and the estate no longer owes any taxes to CRA. So that's a very important step to take if you're an executor, just to cover off your personal liability for any income tax that might be owing to CRA. The executor, of course, has to pay all the debts of the estate from the estate funds, and that includes any taxes that are owing. It's important to keep yourself organized when you're the executor and to keep organized and careful accounting records of all money and personal property that comes into the estate and goes out of the estate during your administration. So as the executor, you're required to account to the beneficiaries from the date of death forward. And so you account for all assets or incoming funds into the estate and anything that you've paid out in terms of debts and expenses, in addition to any distributions that you make to the beneficiaries. Uh, so you the executor would typically provide all of the beneficiaries with what we call an accounting. It can be a very simple financial statement that sets out all of the incomings and outgoings, and can have receipts attached if the beneficiaries want to look at the source documents to verify the work of the executor. And so once all the debts and expenses of the estate are paid, then you're in a position to account to the beneficiaries and then to distribute, first of all, the specific gifts and personal items to the beneficiaries as outlined in the will or required under intestate succession law. And then, so a specific gift would be where in a will, the the deceased has said, for example, to each of my grandchildren, I leave $10,000, then you'd have to pay that specific gift to each of those grandchildren. Or, if there is an item of personal property, such as a vehicle has been left to a specific person, that is a specific gift that has first priority to be paid to beneficiaries. And then whatever is left over after the specific gifts are paid out forms the residue of the estate, and that residue gets distributed to the residuary beneficiaries. So in a will, there might be a few specific gifts given to some beneficiaries, and then it's common to say, and then I distribute, I direct my executor to distribute the residue of my estate equally among my three children. And so the executor would then take whatever's left over and divide that in three and distribute that to the residuary beneficiaries. So we've already covered some of this. So prior to that distribution to the residuary beneficiaries, you want to account to those beneficiaries. And in that accounting, you want to set out what your compensation will be as an executor. So unless there's a contrary intention expressed in the will, an executor is entitled to compensation, and our legislation says that an executor is entitled to fair and reasonable compensation. This sometimes can be a little bit of controversy with beneficiaries. They don't always agree that an executor might be entitled to compensation, but in fact, executors are entitled to be compensated for the work that they do. For anybody who's ever been an executor, we know that it can be a very difficult task. There can be a lot of work involved. It might require taking time off your job to fulfill the duties of an executor, to go to banks and that type of thing, to organize bank accounts. And so there's a lot of work, a lot of steps that are involved. And, the government wants to encourage people who are named as executors to fulfill that duty as an executor. And so in order to do that, they know that reasonable compensation for their time and effort to do that is required and reasonable. And so I always encourage all of my executors to take reasonable compensation for the work that they have done. And that compensation will vary depending on the complexity of the estate and how difficult it has been to administer the estate and the time that was required to fulfill all of the duties of executor. And then the executor will prepare the final accounting that will set out the compensation that they're going to take. It would set out all of the accounting fees and the legal fees that have been paid to professionals to assist the executor in distributing the estate. And so the executor sends that accounting out to the beneficiaries with a release where the beneficiaries have the opportunity to get legal advice if they want to. On the accounting, they see where all the assets that have come into the estate and all the expenses and debts that have been paid out of the estate. And if they agree with all the steps in that accounting that the executors have taken, then they would sign a release that would release the executor from any claims that beneficiary would have against the executor for the work that they have done. And so after the executor has all of the releases signed by the beneficiaries, that's when they would make a distribution to the beneficiaries, the residuary beneficiaries of the estate. And that is often done in different increments or different steps. So often there's an initial distribution to the beneficiaries. Some money is held back while final tax returns are paid and you're waiting for CRA to assess that final tax return. Perhaps you're waiting for the clearance certificate from CRA. And then once all of those final taxes are paid, then the balance of the estate can be paid out to the beneficiaries. So there's often at least two distributions to beneficiaries, an interim distribution, and then a second distribution later, once you know that everything has been taken care of, and most importantly, all the income tax has been paid. So it's really important as an executor to record everything that you do, to keep good record, very good, clear records of what you're doing, record the time that you're spending in doing all of these tasks. And I would, if I could give one piece of advice to executors, it is to maintain good communication with the beneficiaries of the estate. So many of the problems that arise in estate administration are because the beneficiaries feel like they're not being kept informed of the executor's progress and what's going on in the estate. So regular communication with beneficiaries will often just satisfy beneficiaries that that things are moving ahead. The executor is attending to all the tasks that are required of them. Maybe there are some difficulties that have arisen with the administration of the estate, letting beneficiaries know what that is, and setting out some reasonable time frames, giving them some idea of how long things are taking, goes a long way in just letting the beneficiaries know that the executor is on it, they have it under control, they're dealing with everything in a step-by-step fashion, in a reasonable fashion. Hopefully they're, if required, there's a lawyer that is helping them through those steps. They're following that legal advice and they're attending to all of those matters. And in addition to keeping beneficiaries informed, it's always a good idea to keep claimants and creditors informed, because they can sometimes be your worst nightmare as an executor. So just like beneficiaries, if they know what's going on and they're satisfied that an executor is attending to their duties, then they're much less likely to become worried about the estate administration and start asking difficult questions or putting pressure on the executor to get things done. So that's really a very quick summary of the tasks that are involved in being an executor and administering an estate. And I'm happy to take any questions that are out there.
Yeah, thanks, Shelly. And we've got lots of questions for you. Some of them are similar, so I'll try to keep the similar questions together. But yeah, let's just dive right in. Lots of good questions here. You started your presentation talking a little bit about funerals. So if there's no surviving spouse and there's a disagreement amongst the adult children about the funeral arrangements, what's the role of the executor in that disagreement, or is there a role?
So the executor has the authority to make funeral arrangements. So they are the arbiter, they are the person who makes the final decision, and the funeral home should be taking instructions from the executor. Now, let's say there's two executors and who are the children of the deceased and they don't agree, then the unfortunate result could be that those executors have to make a court application, and the court, the judge will decide, what needs to happen. And that's not, it's not like that's never happened. I've never had to make one of those applications, but our firm does act for funeral homes where they've had to send family members away to go to court and make an application before a funeral will happen. And so that's never a good situation for a family to start out at.
No, it's not. No, it's not. And on that same sort of vein of thinking, can you speak a little bit about co-executors and whether you think that's a good idea, whether it could create problems, does it, conflict, things like that?
Yeah, I'm of two trains of thought there. So being an executor can be a lot of work, and it is nice to have some help when you're an executor. to share those duties with others. So it's very common when a parent is making a will, and let's say they have 2 children or 3 children, they might decide to name all of their children as co-executors, which is okay as long as those children get along and can make good decisions together. If executors, can't get along, then that's a very difficult position to be in. Um, and it's going to be very difficult to make decisions together, to be of one mind, and to move things forward. I mean, at the end of the day, all of the executors need to sign off on every step unless the will says something different. If the will says that the majority of the executors can make a decision, and you have 3 executors, then 2 out of 3 wins the day. But if the will is silent on that and there's 3 executors, then all 3 executors need to agree on every decision, and so that can be difficult. And banks and other investment institutions, they will require all of the executors to sign off on every step unless an executor has given their authority to their co-executor. So it can be a little bit of a logistical problem sometimes when you have more than one executor. And again, any conflict that can't be resolved through other methods like mediation will be resolved through the court if necessary. So that's time consuming and expensive.
Great, thank you. If an executor is already the power of attorney, do they still have to account for all of the money in the bank accounts?
Absolutely, they do. And so the uh, attorney, under a power of attorney, their authority stops at the moment of death, and then the authority of the executor um, uh, takes over from that point. So as an attorney, you account up to the date of death, and then the executor needs to account from the date of death going forward. And it is common for attorneys to be challenged by an executor, if they're different people, about what happened prior to death. So an attorney is required to account, and an executor is required to account. And if there's the same people, it might be the beneficiaries that require an attorney to account, which is really the executor accounting for their actions prior to the death of the deceased.
Sounds great. You mentioned getting a grant of probate. Where does one get that? Where does that come from?
So a grant of probate, in order to get one, there is an application that has to be submitted to the court. So if the deceased died in Alberta, it's submitted to the court in Alberta. So there's a prescribed form. It's fairly complicated. You don't need to have a lawyer to prepare and submit an application for probate to the court. But what I can tell you is that I've acted for a number of clients who have attempted to do that on their own, and after a number of attempts and rejections from the court, they have come to hire me or another lawyer to apply to help them get that application in order and apply for that grant of probate. So grant of probate is an order that is issued by the court of Alberta.
Excellent. What if you can't find the will?
So if you can't find the will, it might be that there is no will, or it might be that the testator revoked their will and did that by destroying the will. So that is not uncommon where I deal with families where they're certain that there was a will. Dad said he made a will. Dad said his will was in the safety deposit box. Dad, talked about his will, but nobody can find a will. You have to do your best to search for the will, but at some point, if you can't find the will, then you have to move on without the will. Because one of the ways, as I said, to revoke a will is by destroying it. So if you can't find it, the assumption is that the person who made the will revoked the will by destroying it.
Okay, great. There are actually quite a number of, you talked about compensation for the executor. There are a number of questions around that topic. So what do you advise your clients to be a reasonable amount? And is it can you stipulate an actual amount right in the will? So two-part question.
Yeah, so you can stipulate amount in the will. Sometimes that can be difficult for the person making the will to do because they may not know how complicated their estate is, or how much work will be involved by the executor. They may not know whether they're going to pass away a year from the date that they make the will, or 20 years from the date that they make the will. So will that compensation be fair, reasonable, and relevant at the time that the executor is actually carrying out their duties? So it is a difficult task to decide on compensation in a will, but some of my clients decide to do that. And you can set out a specific amount or a percentage of the estate as a way of deciding what that compensation should be. So our legislation only says that compensation must be fair and reasonable. That's the only guidance we're given in legislation. There were some fee guidelines that were used and relied upon by executors and by the courts in the past. Those fee guidelines have been found to be outdated. They are under review right now, so we are left without fee guidelines for executors. But they were a percentage of the estate, and they would be roughly between 1% and 5% of the value of the estate, is what the old fee guidelines suggested. But many practitioners and justices and courts have found that those guidelines are not relevant anymore. Estates are people are dying with much more wealth than they used to. And so those fee guidelines would give executors compensation that was far beyond what was reasonable. And estates are come in different shapes and forms. So you can have $1 million estate that is made up of one bank account, which would be a very simple estate to administer, and you can have a $1 million estate that has multiple bank accounts, multiple properties that need to be cleaned out and sold, and has a number of children, all of whom are at odds with each other and are fighting, and that would be a very contentious and difficult estate to administer. So the value of the estate is only one of the considerations in terms of what might be fair and reasonable compensation to an executor. So it's very difficult. It's a difficult question to answer, and it's often the most contentious issue that has to be surmounted when it comes to accounting to the beneficiaries and getting ready to make that distribution to the beneficiaries. Is everybody agreeing on what fair and reasonable compensation will be to that executor?
And I'm not sure if you mentioned this or not in your presentation, but that compensation is taxable income for the executor, is it not?
That's right. And so some executors change their mind once they
Once they realize they have to claim it, yeah.
Yeah, there's that. So it's considered to be employment income, and so you have to claim it on your tax return. And so sometimes in the final assessment, an executor will say, "Well, I'm not prepared to, if I'm not prepared to pay the government even more tax, in this circumstance. So I'm not going to take compensation," or they might take less compensation just to decrease the taxes.
Right. There have been a couple of different questions about the notice to beneficiaries. So I'm going to lump like questions together. Is there a standard form that goes out to all beneficiaries, and or can verbal notification be enough, or does it have to be in writing?
Notification always needs to be in writing. And so you want, as an executor, you want to make sure that you have records of giving notice. There is a prescribed form in our rules of court which are called surrogate rules, of the format of the release, and the notice to the beneficiaries. And so an executor is required to give that notice in the form prescribed by the court. You can add things to the notice if you need to add more information. The notice is very basic. It just sets out what the gift is to that beneficiary, and that the beneficiaries have the responsibility of supervising the actions and the tasks of the executor, and it sets out just the name and contact information for the executor or for the lawyer who's acting for that executor. But yes, it has to. So notices must be in writing, and there is a prescribed form.
Great. There are a couple of other questions that are similar around things like RSPs and investment accounts, where a person may be the beneficiary of those accounts, but not joint. Or there was another question where if it's joint. But can you talk a little bit about RSPs and investment accounts as it pertains to that probate? They
Right.
fall outside of probate?
Right. So where you have a registered account, so that's an account where you can name a beneficiary, like an RRSP or a RIF or a tax-free savings account, where there's a beneficiary that's been named, then that account does not form part of the estate, and the funds in that account get paid out directly by that financial institution to that beneficiary. Now, that financial institution might need some help in locating that beneficiary, or executor can help by giving contact information of that beneficiary to the financial institution. But that does not form part of the estate if there is a valid beneficiary designation. Now, if the deceased had named the estate as their beneficiary, which you can do, or if they did not name a beneficiary, then by default their estate is the beneficiary. Then that account comes into the estate, and is the task of the executor to distribute it with all the other assets in the estate.
Okay, sounds great. There are a couple of questions around timelines. How soon after the person's death do you have to give notice to beneficiaries? Is there a timeline around probate? And I know that varies, but maybe give us a sense of timelines for
Right.
the executor.
So there's this concept of an executor's year, and it's not set out in our legislation, but sometimes courts have referred to it in court cases. And the idea is that in the first year of death, for most estates, so this wouldn't apply to really complicated estates, but in the average estate, an executor should be able to apply for a grant of probate or administration, if it's necessary to apply for a grant, and have done that first distribution to beneficiaries within that first year. And so when you're giving notice to beneficiaries, that's the notice goes out. The notice is part of applying for probate or for applying for a grant of administration. So that should certainly be done in the first year of an average estate. And I can tell you that once those notices go out to beneficiaries, that the clock really starts ticking on executors. Then they are really on the beneficiary's radar to get things moving. And so when you are applying for probate and sending out those notices, you want to have as much work done as possible, because you know that those beneficiaries are going to start to be asking questions about when they're going to receive funds from the estate. I have lots of beneficiaries who are out spending money long before they're ever going to get the estate proceeds. So that's really when the pressure does ramp up on the executor. So there's no hard and fast rule for when those notices have to go out and when you have to apply for a grant of probate, except to say that the courts consider that you would do at least that in the first year, and that you would be able to make some sort of distribution to a beneficiary in the first year, unless there's some other circumstances that are preventing that. And so executors should, in most average estates, be able to move the estate along, through that process of applying for probate and being at at a point where they can at least start to account to the beneficiaries and let them know what the distribution, what their share of the estate is going to look like.
Great. And so on that note, a little bit, what if the beneficiary or a family member thinks that the executor is not doing their job, or a similar question, but it's the other way around, an executor thinks that a family member is maybe taking advantage, or going into mom and dad's house to clean it out, things like that. So I guess it's a two-part question.
Right. So I'll deal with that second question first. So again, it's the executor's responsibility to secure the assets of the estate. That means securing the property. So that means gathering all the keys that get you into mom's and dad's house. And if you're not able to do that, that means changing the locks, right? And keeping people out who aren't entitled to be in that house. And so really, it's just the executors who are entitled to go into that property and to take things. So the executors have to be, somewhat forceful sometimes in that circumstance, and make sure that they're able to secure that property. And again, if they're not, then changing the locks is might be the solution to that problem. But certainly, you, as an executor, you wouldn't want to allow people to go into a house and take things without you being there. So oftentimes personal possessions are distributed first, and so there might be a big family gathering or meeting in a house where among the beneficiaries, they'll decide who's going to get what of the little knickknacks that are in the house or the furniture or whatever. But that should never be done without the executor's supervision and permission. So executors need to be forceful in that way and maintain control over the property. And if that's not possible, then you might have to bring a court application to keep people out, or to get the locks changed, or whatever needs to be done to secure that property. But that is a problem in a lot of contentious estates, is people going in and taking what they want, and that often happens very quickly after somebody has passed away. So it's an important that if you know that you're an executor, to get in there right away and to secure the property.
Yeah. And then the flip side, what if the family thinks that the executor is not doing a good job or is abusing their privilege?
Right. So as a beneficiary, if you feel like an executor is not moving forward with their duties, the best thing to do would be to contact that executor and ask them questions about where they are in estate administration and what their plans are. And if you get you know if you have kind of a head in the sand executor who's not taking any steps, maybe they don't know what to do, or they haven't decided if they want to act, or they just have decided that they don't have to do anything. The ultimate resolution to that is for the beneficiaries to bring a court application, setting out what the issues are, and then asking the court to make some direction. So asking the court to put timelines on the executor to start taking steps and fulfilling some of those tasks that we talked about. So for example, if you have an executor who hasn't applied for a grant of probate after a year, and there's no good reason why that is the case, it's a fairly simple estate, there's no hangups in the estate, then that's the ultimate step that the beneficiaries have at their disposal, is to bring a court application asking the court to intervene and to help them with forcing this executor to either get busy and administer the estate, or renounce and allow somebody else to apply to be the executor and take over with the administration of the estate.
Great, thank you. Can a lawyer or a law firm be an executor of an estate?
A law firm cannot, but in that you need a person. A person needs to be an executor. So you can appoint a lawyer and some lawyers will agree to be executors of an estate. Accountants sometimes will agree to be executors of an estate. So the only non-individual who would be the executor of an estate is a trust company, and so their role specifically would be to be you can appoint a trust company to be an executor of an estate. So I have had circumstances where the executors who are appointed don't want to be the executors of an estate, but all the beneficiaries agree that they'd like to appoint a trust company to fulfill the duties of executor and carry out the distribution of the estate. And so they would appoint a trust company. And then within that trust company, there would be a trustee that is appointed as the contact person, or the individual who would be appointed to carry out the duties of executor for that trust company.
Okay, sounds great. Thank you. We've got a lot of questions. They keep rolling in. Actually, the list is getting longer, not shorter. So is there a timeline for that tax return, that terminal tax return you talked about?
Yes. So depending when the deceased passed away, I believe the time frame is that the terminal return has to be filed the later of 6 months from when the deceased passed away, or when you would file when that deceased would have filed their tax return. So like the April tax returns that we're filing now. So they get the longer of that period to file that first terminal tax return, and then the next tax return would be filed on the anniversary of that of the first of the date of death. But I believe now CRA is moving all of those tax returns to a December 31st date. So you might file a shorter estate tax return and then file like on a calendar year basis after that.
Great. This is an interesting question because of the digital age we're in now. Can you speak a little bit about the executor's role on social media and digital assets? Those are a little harder to come to wrangle than just changing the locks on the house, right?
They are, right? And probably one of the most difficult estates I think that we'll have coming up is where you have somebody who's passed away who had done everything electronically, right? So there's no paper trail of anything, and so that means you're hoping that you have their passwords for all of their bank accounts and everything that you're going to need access to. But in terms of social media, this is still a question that's up in the air. As between the social media, companies and their users. So in the contracts that none of us read, the terms and conditions, when we sign up for Twitter or for Instagram or whatever social media accounts we have, those accounts have different rules about what happens when somebody passes away. And most of us would be, frightened to know that some of those rules might be that the social media provider actually owns those accounts and owns the information in the account. So it can be very difficult dealing with them. It can be very difficult to close down, for example, a Facebook account or an Instagram account. They're getting better. There's more court challenges for more reasonable terms and conditions in some of these social media contracts that would allow executors and family members to take control of those accounts and close them down. But it's a very difficult thing to do, and I have to say that for the time being, the social media providers are winning that fight, but I think the tide will be turning in the next few years. But it can be difficult, and you have to be very persistent with them to get accounts closed and photographs and information and taken off of sites, and sites closed down permanently.
That's great. We're getting close to the 8 o'clock time here, and we still have over 100 questions, believe it or not, Shelly. A very popular topic. But I'm going to ask you one last question. But before I do, special thanks to Stella for catching a typo on our screen right now. Shelly's email address is incorrect. We're missing an H.
Yes.
So it's S. Chamaschuk with an H. So you'll see her name in blue. So yeah, the email address is missing a second H there at the end.
Thank you for pointing that out. That's
thank you,
error.
Stella. That's
Thank
awesome.
You,
That's great. And so because we aren't able to get to all of the questions, my apologies. Like I said, I still have 105 open questions. So we're going to run out of time. A lot of these questions are very specific, Shelly. So I'm going to invite our listeners and our viewers to reach out to you if they've got a very specific question that is case specific, so that way they can address their own particular need. I see that the sun is shining on my face here. So I'm going to ask one last question, and this might be a loaded question for you, given your role, Shelly. But it sounds like the role of executor is quite complicated. So do you, in your professional opinion, think that this is something that a typical person like me can do, or should someone like me hire a lawyer to walk them through the executor process?
Yeah, I think that most executors, first of all, an executor needs to carry out their role in a prudent manner. And I think the court would agree that a prudent manner would mean getting at least some legal advice in carrying out your duties. So I have a lot of clients who come to me who start the administration of an estate and quickly run into trouble because they have a difficult beneficiary who's challenging them, or they're having trouble with a bank or another institution, or they're just having a hard time working themselves through the process, and that's very understandable. It's complicated. It's important. There are some, there's some personal liability involved, and there's no way that the average prudent person would know what steps that they need to take to be an executor. So I think that it makes really good sense to hire a lawyer to get advice, to help walk you through the steps. And I have executors who rely on me heavily for each and every step that they take. And I have other executors who just call me occasionally to ask questions. Often my role is to help them put that probate application together, get that submitted to the court, get that grant of probate, and then a lot of my executors can kind of take off from there. They go out, they deal with the banks and, list property for sale, clean out the house, sell the land, that type of thing. And they just come back to me occasionally when they need some help. And then when they're ready to do that distribution, they might come back and say, okay, can you help me prepare the releases? Can you help me with my accounting, make sure that my accounting makes sense and I have everything I need to send out to the beneficiaries? So really just some guidance through those steps. Remember that that the legal fees and the accounting fees are paid from the estate, so that's not a personal expense of the executor. I understand that often executors will be beneficiaries of the estate as well, but it can be money that's really well spent if it creates a timely and organized administration of an estate that keeps all of the beneficiaries satisfied, that the executor is moving things forward in a timely manner and doing things that are appropriate and in accordance with the law. I think that I think that the expense in hiring a lawyer is well worth a peace of mind to both the executor and the beneficiaries, knowing that that estate is being administered properly.
That's great. Thank you. I'd love to keep asking you questions, and I'm sure our viewers would as well. Like I said, we didn't have time to get to all of your questions. So if you want to reach out to Shelly, please email her. Don't forget the second H, Chamaschuk. And Shelly, thank you so much for joining us today. That's wonderful. Everyone, please remember this session is being recorded, and so it will be available on our website. That address again is www.ecfoundation.org. So it will be on the Edmonton Community Foundation website. We'll be getting all of the sessions up onto our website by the end of the month. So please check back in a couple of weeks. Please invite your family and friends to look at one or all of the sessions. We're featuring 9 sessions this week, and Shelly's session tonight was the 4th session. So we still have a few more this week. And again, Shelly, thank you so much for taking the time, for volunteering your time to answer people's questions and to provide some very valuable information on a very, very important topic. I know this is something I'm going to have to deal with one day, and so I learned a lot today. So thank you very, very much.